Hey, it's Mark here, and welcome to the next edition of the Employee Survival Guide, where I tell you, as always, what your employer does definitely not want you to know about, and a lot more.
Welcome to another episode of the Employee Survival Guide, produced by employment attorney Mark Carey. Imagine for a second that you are sitting in an HR office.
Oh, we've all been there.
Right. It is your very first day on the job at a pretty prestigious company, and you are staring down this massive stack of onboarding paperwork.
The dreaded first day paperwork mountain.
Exactly. And, tucked away on like page 14 of the employee handbook, just completely buried in the fine print, is an arbitration clause.
Which, let's be honest, you sign without a second thought.
Oh, absolutely.
Yeah.
Almost everyone does. But by signing your name, you are fully expecting that any future workplace dispute, whether it is a fight about your schedule or a discrepancy with your
or a failure to provide medical accommodations.
Yeah, you're agreeing that all of that will be handled entirely behind closed doors. You are agreeing to this private arbitration setting, completely away from the public eye.
No jury, no public record.
Right. And it's heavily controlled by the parameters your employer set. That is just the reality of the modern American workplace.
It is.
But now, imagine a brand new federal law stepping in and completely invalidating that ironclad contract. Picture that law just pulling your entire lawsuit out of that secret private room and thrusting it directly into a public federal courtroom for the whole world to see.
And, the craziest part about this scenario isn't just that the contract gets invalidated. It is the actual mechanism that triggers the invalidation.
What do you mean?
Well, the legal ground completely shifts underneath both the employee and the employer based entirely on the specific, granular mix of claims that the employee decides to file in their lawsuit.
Oh, wow.
Yeah, you think you understand the rules of engagement when you sign that contract, and then one specific allegation acts as a skeleton key. It just unlocks the entire system.
So if you are an employer drafting these restrictive contracts or, an employee navigating the reality of signing them, this recent decision out of the Sixth Circuit Court of Appeals just blew up your playbook.
Oh, completely destroyed it.
The case is Randi Marie Bruce v. Adams and Reese, LLP. It was handed down on February 25, 2026. And today, we are unpacking the really intense facts of this workplace conflict.
And we're analyzing the monumental importance of the act Ending Forced Arbitration.
Right, commonly known as the EFAA. We are going to look at how one single word, literally one word in a statute, is fundamentally changing the landscape of employment law.
Because this case, it is a perfect storm.
It really is. It combines this highly complex employment history with deeply disturbing allegations of misconduct. And it ends up being this high-stakes, scorched earth battle over access to the federal court system.
Yeah, and getting through those courthouse doors truly is half the battle in civil litigation.
For sure.
Corporate defendants spend millions of dollars every single year specifically to keep plaintiffs out of those courtrooms.
It's a massive industry in itself.
Exactly. And this case illustrates exactly how abstract legal doctrines, things like statutory interpretation, federal pleading standards, and corporate vicarious liability violently collide with the messy human realities of an actual workplace.
Okay, let's unpack this by starting with that human element.
Yeah.
Because before we can even touch the groundbreaking legal interpretations regarding arbitration, we have to understand the people involved, right?
Yeah, I need the context.
We need to introduce the plaintiff, Randi Marie Bruce. And to fully grasp her situation, we have to look at her background, which is marked by a pretty severe and compounding series of health challenges.
Right, it's not just one thing.
No, the complaint details that she has a history of childhood abuse and has been diagnosed with a multitude of overlapping conditions.
And the list of diagnoses is extensive. It paints a picture of someone carrying an immense psychological and physiological load every day.
Yeah, what are we talking about here?
We are talking about post-traumatic stress disorder, attention deficit hyperactivity disorder, social phobia, persistent depressive disorder.
That's a lot to manage.
It is. And on top of that, sleep apnea, insomnia, and restless leg syndrome. So when you combine all these conditions, you are looking at an individual who requires highly specific medical management just to function in a standard professional environment.
Right. And the reality of those invisible disabilities is absolutely critical here. To manage this heavy burden, Bruce required medication.
Specifically powerful sedatives, right?
Yes, sedatives to help her sleep through the night. But in the context of a really demanding corporate job, those sedatives created a massive secondary issue.
Because they make waking up incredibly difficult.
Exactly. They led to a severely delayed response in the mornings. Waking up shaking off the effects of the heavy sedatives, and, commuting to an office at a strict early hour became virtually impossible for her.
So she needed an accommodation.
She did. Because of this physiological barrier, her primary required accommodation was a flexible morning schedule.
And that need for a flexible schedule forms the absolute backbone of her entire employment timeline.
Yeah.
It is the central tension that eventually just snaps. So we have to trace her career path to see how that tension escalated over time.
Okay, where did she start?
She was originally hired as a legal assistant at the Waller law firm back in 2019, working specifically within their liquor group.
And then, like millions of others, she faced a disruption during the COVID-19 pandemic.
Right, she was temporarily laid off.
But she returned to the Waller firm in April 2021. And by all accounts, her work product was excellent.
Yeah, we actually know this for a fact because by March 2022, she was officially promoted to the role of paralegal.
Okay, so she's doing well.
Right, and the most important detail about her time at the Waller firm is that her medical accommodations were actually being met.
Oh, really?
Yeah. Up to this point, the firm allowed her the flexible schedule she desperately needed to manage her sedatives. She could clock in and out in a way that accommodated her delayed mornings without sacrificing her career progression.
That sounds like a pretty functional arrangement. Yeah. But then we hit the major transition, right? The pivot point of the entire narrative.
Yes.
In May 2022, the entire liquor group, which includes Bruce and her direct supervisor, an attorney named Rob Pinson, transfers to a completely different corporate entity.
Right. They go to the law firm of Adams and Reese, or A&R.
And group transfers like this are super common in the legal world, aren't they?
Oh, yeah. Partner or senior attorney decides to jump ship to a new firm, and they just bring their entire book of business and their support staff right along with them.
So from the outside, it just looks like business as usual.
Exactly. While common in the industry, though, this specific transfer is the hinge on which a massive amount of the court's legal analysis swings.
Why is that?
Because Bruce is moving to a brand new employer on paper, but she is taking her old supervisor the exact same power dynamic and her exact same daily workflow with her.
So nothing really changes for her day-to-day.
To her, the job might feel identical, but legally. The slate is wiped totally clean in ways that will severely complicate her lawsuit later on.
Which brings us directly into the specific allegations of sexual harassment.
Right.
Bruce alleges that her supervisor, Rob Pinson, harassed her extensively. Now, when you read the actual complaint, she details abhorrent behavior spanning across their time at both law firms.
Yes, it's a very long timeline in the complaint.
But if we focus strictly on the environment after they moved to Adams and Reese, the allegations are incredibly striking.
Because Pinson isn't even in the office every single day, right?
Exactly. But Bruce claims that whenever he is present, he continuously makes sexual comments, inappropriate jokes, and highly invasive remarks about her appearance, her clothing, and, her private life.
And the complaint doesn't just rely on vague accusations. It gets highly specific about the nature of this behavior.
Give me an example.
Well, it outlines this deeply bizarre and crossing-the-line situation where Pinson gave Bruce a $750 bonus directly out of his own personal finances.
Wait. His personal bank account?
Yes. And in a corporate law firm, bonuses are handled by HR and payroll. A partner writing a personal check to a subordinate paralegal is a massive red flag.
I would say so. That completely blurs professional boundaries.
It does. It establishes this really inappropriate financial power dynamic right out of the gate.
And it sets the stage for the verbal harassment that follows. The complaint alleges he would repeatedly suggest, out in the open and in front of other colleagues, let's have Randi go down there in a short skirt.
He would say that when discussing client meetings, right?
Yeah, or just running firm errands. It also claims he would use the phrase, ho no, instead of oh no, when speaking directly to her.
It's just incredibly degrading.
It really is. And the allegations culminate in a specific incident detailed in April 2023, where Pinson allegedly commented about how hot it would be to see Bruce and another female paralegal perform sexual acts on his desk.
Oh, wow. And you really have to view these comments through the lens of the power dynamic we just discussed.
Right.
This isn't a peer making an off-color joke. This is the man who completely controls her workflow, her evaluations, and her employment status, graphically fantasizing about her in the workplace.
It creates a highly volatile, toxic work environment. And all of this intense psychological stress is happening while Bruce is simultaneously fighting a losing battle regarding her health accommodations at this new firm.
Right, because things changed at A&R.
They did. This leads us to the climax of her time there. By October 2022, which is just a few months after the transfer, Adams and Reese management tells her she have, quote, communication issues.
And what do?
They completely strip away her flexibility. They place her on a strict, fixed morning schedule.
Which we know she medically cannot handle.
Exactly. She attempts to manage this rigid schedule for a while, but biology wins out. By March 2023, her delayed response to the severe sedatives returns in full force.
So she starts arriving late.
Yeah. And in a corporate law firm, tardiness is often treated as a cardinal sin.
Oh, absolutely.
Which leads to intense, highly adversarial HR meetings. In one specific meeting with the office manager, another attorney, and Pinson himself, she is explicitly told she could be terminated if she's late again.
They actually pressure her to sign a formal corrective action memo right there in the room, don't they?
They do. And given her documented history of trauma, her PTSD, and her severe anxiety disorders, being cornered in a room by management and threatened with termination triggers a severe panic attack.
The environment has just become completely untenable for her.
It has. Desperate to save her job, she tries to switch her medication to something that won't cause the morning delays, but the new medication simply doesn't work for her sleep apnea and insomnia.
She's in a totally impossible situation.
She is.
Yeah.
She's actively trying to get her personal doctor to communicate directly with A&R's Human Resources Department to explain the medical necessity of the flexible schedule.
But time runs out.
Yeah. Before that dialogue can resolve the issue, she arrives late again. And on May 11, 2023, Adams and Reese officially terminates her employment.
So the fallout of all this is a comprehensive federal lawsuit. Bruce files a complaint that includes two completely distinct legal tracks.
Okay, what's the first track?
First, she files claims for sexual harassment and a hostile work environment under Title VII of the Civil Rights Act.
Got it. And the second?
Second, she files claims for the failure to accommodate her disability and wrongful termination under the Americans with Disabilities Act, the ADA.
So I am looking at this massive complaint, and Bruce is outlining a mountain of bad behavior by Pinson. She has 42 separate paragraphs detailing sexual harassment that allegedly occurred before they even moved to A&R.
Right, during their years at the Waller firm.
But when the Sixth Circuit Court of Appeals gets their hands on this case, they explicitly ignore all 42 of those paragraphs. They just toss years of alleged abuse out of the analysis completely.
It seems harsh, doesn't it?
It really does. Why does the federal court draw such a brutal, hard line in the sand regarding her timeline?
Well, the court is bound by a fundamental, non-negotiable concept in corporate liability law called vicarious liability.
Okay, what does that mean in this context?
When Randi Bruce files this lawsuit, she isn't just suing Rob Pinson, the individual. She is suing Adams and Reese, the multi-million-dollar corporate entity.
Right.
She is essentially arguing you, the company, are legally responsible for the actions of your employee. But the strict rule of vicarious liability dictates that an employer can only be held liable for an employee's conduct if that conduct occurred while the harasser was actually employed by that specific company.
And while the victim was employed by that company too, right?
Exactly.
Okay, let's unpack this. It's like trying to sue your current apartment landlord because you had a leaky roof at your previous apartment across town, just because the exact same maintenance guy happens to work at both buildings now.
That's a great way to put it.
The liability doesn't travel with the maintenance guy. It stays attached to the property owner at the time the damage occurred.
Building on that analogy, the legal boundary is a brick wall. The court's perspective is entirely structural here. Adams and Reese was not Bruce's employer during the Waller years. And more importantly, Adams and Reese was not Pinson's employer during the Waller years. They had no legal authority over his behavior, no ability to discipline him, and, no duty to monitor him before May of 2022.
So they are off the hook for all of that.
Therefore, as a matter of pure corporate law, A&R cannot be held vicariously liable for anything Pinson did before the transfer. The federal court is legally required to put blinders on and look exclusively at the isolated one-year period where both individuals were on the A&R payroll.
Which artificially shrinks the timeline and drastically reduces the sheer volume of the allegations the court is allowed to consider.
Dramatically.
It isolates Bruce's Title VII claim to just the incidents that happened during those final 12 months.
And that sets up a terrifying challenge for Bruce and, frankly, for any plaintiff in employment litigation.
Because surviving the very first procedural phase of a lawsuit is notoriously difficult, right?
Oh, it's incredibly hard. before you ever get to step in front of a jury, before you are allowed to subpoena the company's internal emails, and before you can force the harasser to sit for a deposition under oath, you have to survive the pleading stage.
The pleading hurdle. So Adams and Reese looks at the lawsuit. They see that 42 paragraphs of the bad behavior have been legally neutralized by that corporate boundary.
Yeah.
And they immediately file a motion to dismiss the sexual harassment claim. They utilize Rule 12b-6 of the Federal Rules of Civil Procedure.
A classic defense move.
To put it in plain English, a 12b motion basically says to the judge, Your Honor, even if every single word this plaintiff wrote in her complaint is 100% true, it still isn't enough to constitute a valid legal claim, so you must throw it out right now.
And we have to explore why Rule 12b-6 is used as such a lethal weapon by corporate defense attorneys.
Is it just about ending it quickly?
It is all about the staggering asymmetrical costs of modern litigation. In an employment dispute, the plaintiff usually has very little evidence up front, maybe a few saved emails or text messages, if they're lucky.
Right.
The company, on the other hand, holds all the cards. They have the internal HR servers, the Slack channels, the personnel files. If a case survives a motion to dismiss, it enters the discovery phase.
And discovery is the monster hiding in the shadows of every civil lawsuit.
Exactly. Discovery is a bloodbath. It can cost a corporation hundreds of thousands of dollars to hire outside counsel to collect, review, and produce years of digital communications.
Not to mention the disruption.
Right. It forces executives to sit for hostile depositions. Employers fight to the death at the 12b stage specifically to kill the lawsuit before that expensive discovery floodgate is forced open.
And the dam holding back those floodwaters is a legal standard set by the Supreme Court.
Yes.
If you are going to survive a motion to dismiss today, you have to satisfy the modern federal pleading standard, which is universally known in the legal world as the Twombly-Iqbal standard.
Named after two landmark Supreme Court decisions from 2007 and 2009.
Right. So how did these two cases change the game for plaintiffs like Bruce?
Well, before Twombly and Iqbal, the American legal system operated under a much looser, more forgiving standard. You basically just had to give the defendant fair notice of what you were suing them for.
Just a general heads up.
Pretty much. As long as your complaint wasn't complete nonsense, you generally got the keys to the discovery kingdom. But the Supreme Court, heavily influenced by the soaring costs of corporate litigation we just discussed, decided to raise the bar significantly.
What do they require instead?
They ruled that a complaint doesn't need exhaustive encyclopedic detail, but it absolutely must contain enough specific factual matter to state a claim that is plausible on its face, not just merely possible.
Plausible, not just possible. That sounds like a subtle semantic difference. But in practice, it is a massive chasm.
It shifts massive power to the subjective judgment of the trial judge. A judge has to look at the facts alleged and be able to draw a reasonable, logical inference that the defendant is actually liable for the misconduct.
So you can't just guess or assume.
Right. You can no longer just list legal conclusions. You cannot simply write a complaint that says, my boss harassed me, therefore I am suing for harassment.
Because that's just a conclusion.
Exactly. You have to provide the factual meat on those bones, the who, what, when, and where, to make the legal conclusion of harassment plausible to a skeptical judge.
And when we look at Title VII sexual harassment claims, specifically the allegation of a hostile work environment, the legal standard the plaintiff has to meet is notoriously strict, isn't it?
Very strict.
The harassment cannot just be annoying or offensive. Under the law, the conduct must be severe or pervasive.
And that disjunctive or in the legal standard is doing a tremendous amount of heavy lifting. You don't necessarily need to prove both.
Okay, so how does severe work?
A single isolated incident of extreme physical severity, like a physical assault, could be enough to trigger liability on its own.
And pervasive.
Conversely, conduct that isn't physically threatening but is relentlessly pervasive, happening constantly day in and day out, can also create a hostile environment.
So A&R's defense attorneys look at the isolated one-year timeline at their firm, and they pounce on this standard.
Only.
They argue to the court, look at the actual text of her complaint. After stripping away the old firm's history, she only listed 2 or 3 specific, isolated comments over an entire 12-month period.
Which is their main weapon here.
Right. They say 3 inappropriate jokes over a year is definitely not severe enough to meet the legal threshold, and it is mathematically impossible for 3 comments in a year to be considered pervasive.
And A&R has a very strong historical argument here. If you look at decades of past Sixth Circuit case law, a hostile work environment claim that is premised on just 3 or 4 instances of harassing comments spread out over a long period almost always fails the pervasive test.
Because it's just too infrequent.
Yes, courts generally view that leveling in frequency as standard, albeit unpleasant, workplace friction, rather than a pervasive, legally actionable environment of hostility.
So Bruce's entire lawsuit is hanging by a thread.
Uh-huh.
But Judge Moore, writing for the majority in this Sixth Circuit decision, interprets Bruce's complaint through a wildly different lens.
A very creative lens.
And the survival of this multi-million-dollar litigation comes down to the grammatical tense of a single word.
It is a brilliant, almost forensic example of how closely appellate judges read these federal complaints. The majority zeroes in on the specific phrasing Bruce's lawyers used.
The complaint didn't just state, Pinson said this specific thing on this specific date.
No, I didn't.
Instead, it stated that Pinson would say these offensive things. He would say, let's have Randi in a short skirt. He would say, ho, no.
And the Sixth Circuit Court of Appeals literally pulled out a copy of the Merriam-Webster dictionary.
Wait, literally a dictionary?
Yes. They looked up the definition of the auxiliary verb would and formally noted in their opinion that the word is defined as expressing custom or habitual action.
Oh, I see where they're going with this.
By heavily weighting the plaintiff's use of the phrase would say, the court inferred that these comments were not just isolated one-off events that happened 3 times. They inferred that the harassment was regular, habitual, and ongoing throughout her time at A&R.
Wait a minute. Does the grammar of a single sentence really carry that much weight in a federal lawsuit?
It did here.
I am having a really hard time buying this logic. We're talking about a federal lawsuit that could cost a corporation immense financial and reputational damage. Are we saying a case survives, bypasses the 12V shield, and triggers the bloodbath of discovery just because a paralegal's lawyer happened to type the phrase would say instead of the word said?
I know, it sounds wild.
It sounds less like rigorous legal analysis and more like the court is just handing the plaintiff a massive linguistic loophole to save a weak complaint.
I completely understand the skepticism, and corporate defense lawyers across the country are echoing your exact frustration right now. But what's fascinating here is you have to view this through the specific mandate of the Twombly-Iqbal framework.
How so?
At the motion to dismiss stage, judges are explicitly instructed by the Supreme Court to use their judicial experience and common sense. And more importantly, they are legally required to draw all reasonable inferences in favor of the plaintiff.
So they have to give her the benefit of the doubt.
Yes. They have to view the complaint in the light most favorable to the person bringing the lawsuit.
So the court is saying that their interpretation isn't just about weaponizing a dictionary definition. It is about applying common sense to the broader context of the allegations.
Precisely. You cannot look at the word would in a vacuum. You have to look at the holistic picture being painted.
Which is pretty grim.
It is. You have a young female paralegal. Her direct supervisor, a man who holds total power over her daily employment and career trajectory, gives her a completely unsolicited $750 check drawn from his personal bank account.
That context matters.
Right. He makes habitual comments about her wearing short skirts for clients. He degrades her by calling her a hoe. He graphically fantasizes to her face about her performing sex acts on his desk.
It's a pattern.
When an experienced judge applies common sense to that specific fact pattern, they can reasonably infer that this combination of financial boundary crossing and highly sexualized aggressive commentary creates a plausible environment of persistent intimidation.
It transforms the analysis.
Yeah.
It is no longer just about counting how many times a bad joke was made.
Exactly.
The intense power dynamic, combined with the deeply personal nature of the comments and the grammatical implication that it was habitual, pushes the claim over the line. It makes the allegation of a pervasive hostile environment plausible enough to survive.
And because it crosses that threshold of plausibility, Bruce gets to survive the motion to dismiss.
She wins the procedural fight.
She wins the right to move forward into the discovery phase, where she can finally subpoena the firm's emails, take depositions under oath, and gather the hard evidence required to actually prove her case in front of a jury.
But this decision was not unanimous. Not every judge on the panel agreed with this grammatical lifeline.
Oh, they certainly did not.
We have to look at the dissenting view because it highlights a massive, ongoing, and highly ideological debate in the legal world about how federal rules should be applied.
The dissent was authored by Judge Amul Thapar, and it is a forceful, structurally profound critique of the majority's logic.
You didn't hold back.
Not at all. He takes aim at the very foundation of how the majority interpreted the complaint.
And I want to make sure we are presenting this with absolute impartiality because both sides of this judicial divide are making deeply rooted, highly consequential legal arguments here.
Absolutely.
Judge Thapar argues that Bruce simply failed to state a claim under the law. He points to the stark reality that once the old firm's history is removed, she only provided 3 specific tangible examples of comments over a 1-year period.
Right.
In his strict textualist view, that is legally insufficient to prove pervasive harassment, and he argues the court shouldn't pretend otherwise just to keep the lawsuit alive.
Thapar's critique goes straight to the heart of the Twombly-Iqbal plausibility standard. He accuses the majority of violating Supreme Court precedent by accepting what he calls element as allegation pleading.
What exactly is the danger of element as allegation pleading?
It is a concept where a plaintiff's lawyer takes the specific legal elements required to win a case, and instead of providing facts, they just turn those legal requirements into factual allegations using a thesaurus.
Wait, give me an example of that.
For example, the law requires that harassment be pervasive. So instead of describing 30 specific incidents of harassment to prove it was pervasive, a plaintiff just writes in their complaint that the harassment was persistent, ongoing, customary, and continuing.
So they're just substituting synonyms for actual evidence.
Exactly. Thapar is arguing that Bruce's lawyers just use these synonyms, like the word would, to artificially inflate a weak claim without providing the essential factual foundation of who, what, when, and where.
I see.
He argues that crediting these vague words acts as an illegal loophole around the strict pleading standards. It equates to a threadbare recital of the legal elements, allowing a plaintiff to survive dismissal and trigger the nightmare of discovery without actually providing the facts to justify it.
And there is a glaring factual contradiction in the complaint that Thapar points out, which really makes you stop and evaluate the fairness of the whole system.
The memory issue, right?
Yes. Bruce's complaint was incredibly, meticulously detailed about her time at the old firm. She remembered and documented 42 paragraphs of highly specific dated comments from the Waller era.
Very specific stuff.
But when it came to her time at the new firm, A&R, which was much more recent, she could only recall 3 specific comments, relying instead on that vague would-say phrasing.
It's quite a contrast.
It begs the question, is it fair for the court to fill in the blanks and infer a habitual pattern for the plaintiff when the hard details are mysteriously missing? If her memory was so vivid for the old harassment, why was it so threadbare for the recent harassment?
It is an incredibly compelling point, and it perfectly outlines the structural tension in modern federal law. The courts are trapped in a delicate balancing act here.
Because they can't ask for too much or too little.
Right. On one hand, if courts adopt Thapar's view and demand too much granular detail up front, if they demand specific dates, times, and exact quotes for every single harassing incident over a year before discovery even begins, it essentially creates a heightened pleading standard.
Similar to how the system treats allegations of fraud, right?
Exactly. Under Rule 9 of the Federal Rules of Civil Procedure, if you allege fraud, you have to be incredibly specific from day one because fraud ruins reputations.
But harassment claims don't fall under Rule 9.
No, they don't. Congress has explicitly not required that heightened Rule 9 standard for Title VII employment discrimination claims. They operate under the looser Rule 8.
So the majority is arguing that Thapar is trying to force plaintiffs to meet a grueling standard that Congress never intended for civil rights cases.
Exactly. But on the flip side, if courts demand too little detail, if they follow the majority and let multi-million-dollar cases slide through the gates based on vague auxiliary verbs like would or adjectives like ongoing, then employers are effectively stripped of their 12b6 shield.
They lose their early defense.
They are forced to endure expensive, time-consuming discovery based on ambiguous, impossible-to-disprove accusations. Judges Moore and Thapar are simply falling on opposite sides of this deeply philosophical divide about the role of the federal courts.
Despite the fierce dissent, the majority's decision stands. They rule that the sexual harassment claim survives this tough pleading standard.
It's a huge win for Bruce.
And this procedural victory acts as the trigger for the most important paradigm-shifting part of this entire case. the battle over arbitration.
This is where everything changes.
Because Bruce, surviving that motion to dismiss, sets off a chain reaction that completely changes the trajectory of her lawsuit.
This is the exact moment where the case transforms from a standard, albeit dramatic, employment dispute into a landmark statutory interpretation case that will be cited in textbooks.
Let's talk about the game changer. We need to introduce the Act Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act.
Mercifully abbreviated as the EFAA.
Thank goodness. To truly understand the sheer power of the EFAA, we first have to understand the historical legal monster it was built to fight. The FAA, the Federal Arbitration Act.
The Federal Arbitration Act is a foundational piece of American law. It was passed back in 1925, and its historical mandate is incredibly, almost ruthlessly strong.
What does it mandate?
It requires federal and state courts to rigorously enforce arbitration agreements according to their exact terms. It reflects a deeply entrenched federal policy that strongly favors private arbitration as a necessary tool to clear congested public court dockets and resolve complex commercial disputes efficiently.
And it's everywhere now.
Over the last century, corporate America has weaponized the FAA, putting arbitration clauses in every employment contract, consumer agreement, and terms of service imaginable.
And A&R was fully relying on the unstoppable force of the FAA. They pointed to the 2022 employment contract Bruce signed on her first day.
Right, the one with the arbitration clause.
They said to the court, look, she legally agreed to arbitrate all disputes arising from her employment. We demand that her ADA claims about her flexible schedule, her sleep disorder, and her sedatives be sent to private arbitration immediately.
And historically speaking, under a century of FAA precedent, A&R would win that argument every single time without breaking a sweat.
It would be an automatic win.
The ADA claims would be severed and banished to a private arbitrator.
But in 2021, the legal landscape experienced a seismic shift. Congress passed the EFAA. What exactly is the purpose of this new law?
The EFAA is a highly specific, surgically targeted carve-out to the FAA. It was drafted and passed in the direct wake of the #MeToo movement.
Okay, what was it designed to do?
It was designed specifically to restore access to public courts for victims of sexual assault and harassment. For decades, companies used forced arbitration to quietly settle egregious sexual misconduct claims behind closed doors, preventing the public from ever knowing about serial harassers.
So it brings it all into the light.
Yes. The EFAA's purpose is to shatter that secrecy. It guarantees that victims of sexual harassment have the absolute right to elect to go to an open public federal court, regardless of any contract they signed.
So let's look at the exact word-for-word text of EFAA Section 402A. It says that a pre-dispute arbitration agreement is invalid and unenforceable with respect to a case which is filed under federal, tribal, or state law and relates to the sexual assault dispute or the sexual harassment dispute.
And nested right inside that single sentence is the explosive legal conflict that this entire appellate case revolves around.
Bruce's sexual harassment claim clearly avoids arbitration. Everyone, including Adams and Reese, agrees on that. The EAA explicitly protects her right to litigate the Title VII sexual harassment allegations in public.
That part is undisputed.
But what about her ADA claims? Her allegations regarding her sleep apnea, the failure of the new medication, and being wrongfully fired for being late?
Those are completely separate issues.
Exactly. Those disability claims have absolutely nothing to do with sexual harassment. But they are filed in the exact same lawsuit. They are part of the same legal package.
If we connect this to the bigger picture, you are watching a monumental high-speed collision of congressional intents. On one side, you have the old, heavy machinery of the FAA, which has spent nearly 100 years aggressively pushing every possible case out of the courtroom and into private arbitration.
Right.
And colliding right into it is the brand new #MeToo era EFAA, desperately trying to pull cases back into the light of the public courtroom to protect victims.
And the battlefield where these two massive federal policies meet is the definition of a single word in the statute.
Literally one word.
The entire fight comes down to the word case versus the word claim. This is a masterclass in strict statutory interpretation.
The fate of Bruce's ADA claims and potentially millions of dollars in future corporate litigation strategies across the country rests entirely on how the Sixth Circuit defines the word case.
Let's break down exactly how the court interpreted this text. The court quite literally opens up Black's Law Dictionary, the gold standard for legal definitions.
Right.
How does the dictionary define a case versus a claim?
Well, Black's Law Dictionary defines a case as a civil proceeding, an action, a suit, or a controversy at law. It is the entire overarching vehicle of the lawsuit itself.
And a claim.
A claim, on the other hand, is defined much more narrowly as a singular demand for a specific legal remedy or an assertion of a single right.
So if we think about it visually, a claim is just one individual piece of a puzzle, while the case is the entire completed puzzle board.
Exactly. And the Sixth Circuit leans heavily on a deeply established rule of statutory interpretation called the canon against surplusage.
The canon against surplusage. So the court is basically saying that Congress doesn't waste ink.
That's a good way to put it.
If they put a word in a statute, they didn't do it by accident. It has to do actual work.
That is the exact philosophy of the canon against surplusage. Courts operate on the strict assumption that every single word in a statute has a distinct meaning and a purposeful intent. Congress does not draft extra, useless, redundant words.
So applying that canon to the EFAA, the court says if Congress only wanted to protect this specific, isolated sexual harassment claim from arbitration, they could have easily just written the law that way.
They absolutely could have.
They could have drafted a statute saying the agreement is invalid with respect to the sexual harassment claim. But they didn't write that.
No, they didn't.
They intentionally added extra broader words.
Yeah.
They wrote that the agreement is invalid with respect to a case which is filed and relates to the sexual harassment dispute.
By specifically choosing to use the broad word case instead of the narrow word claim, the court concludes that Congress intentionally and unequivocally broadened the scope of the protection.
So it covers everything.
Yes, the text invalidates the arbitration agreement for the entire lawsuit, not just the single harassment allegation.
The court even compares the drafting of the EFAA to other federal laws to prove this point, specifically looking at whistleblower statutes.
Yes, looking at comparative statutes is a classic textualist move. They look at laws like 18 U.S.C. Section 1514A, which protects corporate whistleblowers.
And what does that statute say?
In that statute, Congress explicitly used the word dispute to limit the arbitration ban only to the specific whistleblower claim itself, leaving the rest of the contract intact.
Oh, I see.
The Sixth Circuit says, look, Congress clearly knew how to surgically carve out just one specific claim when they wanted to. They have done it before, but they explicitly chose not to use that surgical language when drafting the EFAA.
But Adams and Reese pushes back incredibly hard with a terrifying policy argument.
A very realistic fear from their side.
They warn the court that interpreting the law this broadly is going to cause absolute chaos in the employment sector. They argue that plaintiffs' lawyers will instantly abuse this interpretation of the EFAA.
Right, because of the loophole it creates.
If you have an employee with a massive, highly valuable claim for unpaid overtime wages or a complex ADA violation, but they sign an arbitration agreement, their lawyer will just tack on a weak, barely plausible sexual harassment claim to the lawsuit.
Just to game the system.
Exactly. They will use the harassment claim specifically to drag all the unrelated, lucrative claims out of arbitration and into a public jury trial.
It is a very real existential fear from the corporate defense side. They are warning the appellate judges that this literal interpretation turns the EFAA into a legal Trojan horse.
A Trojan horse, right?
A plaintiff hides their real motives inside a weak harassment claim, rolls it past the arbitration clause, and then bursts open in federal court to litigate completely unrelated wage and hour disputes. They argue it will destroy the utility of arbitration agreements entirely.
Here's where it gets really interesting. I like to think of this using a grocery store analogy. Think of your legal claims like individual items you're putting into your shopping cart.
Okay, I'm with you.
You have an apple, which represents the harassment claim. You have a box of cereal, which is the ADA claim. And you have a gallon of milk, which is a wage dispute.
3 separate items.
The case is the actual metal shopping cart holding all of those individual items together.
And following that analogy, under the historical FAA rules, the employer could force you to take the cereal and the milk through a private, hidden checkout lane while only allowing the apple to go through the public register.
Exactly. But the Sixth Circuit is saying the EFAA changes the architecture of the store.
Yeah.
The EFAA doesn't just inspect the apple to see if it's a harassment claim.
It looks at the whole cart.
Right. The law says that if there's a harassment apple anywhere inside that cart, the EFAA waives the entire shopping cart, the cereal, the milk, the whole case through the express lane, completely bypassing the private arbitration checkout.
The whole cart gets to go to public court.
But A&R is basically arguing that people are going to start sneaking one tiny, heavily bruised apple into overflowing carts just to cheat the system and bypass the private checkout.
This raises an important question about the role of the judiciary when faced with policy consequences.
What's the question?
How does a court balance the plain text of a law against the practical reality that the law might be abused?
How does the Sixth Circuit respond to A&R's fear of the Trojan horse?
The court basically shrugs its shoulders and says, that is not our problem. The plain text controls.
So they don't care about the policy outcome.
In the federal system, judges are strictly bound by the words on the page unless following those words would produce a result that is completely fundamentally absurd. And the court formally notes that it is not absurd to let victims bring all of their workplace claims together in one single forum.
In fact, the court argues the exact opposite. They argue that splitting the claims up would be the real absurdity.
Right. Consider the brutal alternative the court outlines. If you force a traumatized victim to fight their complex ADA claim in private arbitration while simultaneously forcing them to fight their sexual harassment claim in a public federal court, you are doubling their legal burden.
That sounds like a nightmare.
The sheer cost of hiring lawyers for two separate venues, the immense time commitment, and the psychological stress of running two parallel high-stakes legal battles would be utterly overwhelming for a normal citizen.
It would ruin them financially.
The court points out that forcing split litigation would likely discourage victims from coming forward to report harassment at all, which directly violates the core fundamental purpose of why the EFAA was passed in the first place.
And the Sixth Circuit actually points out that A&R's fear of the sky falling is a bit overblown. They note that federal district courts across the country have already been interpreting the EFAA this exact way for a few years now, allowing entire cases to bypass arbitration based on one harassment claim, and the judicial system hasn't collapsed.
Exactly. The courts haven't buckled under the weight of these multi-claim lawsuits. The plain text interpretation works in practice, even if corporate defendants despise the strategic disadvantage it puts them in.
Bringing this massive narrative all together, we can see how a single, valid, plausibly pleaded claim acts as a massive, impenetrable, protective umbrella for a plaintiff's entire legal action.
It's an incredible shield.
Because Randi Bruce's Title VII sexual harassment claim was adequately detailed, even if that survival hung entirely on the court's grammatical interpretation of the auxiliary verb would, her entire lawsuit gets to stay in federal court.
That's right.
Her ADA disability claims are shielded from arbitration, and the restrictive employment contract she signed on her first day is completely neutralized.
It is a stunning demonstration of the immense cascading power of federal pleading standards. It shows exactly how a single word in the plaintiff's complaint can interact with a single word in a federal statute to override decades of entrenched contract law and arbitration precedent.
So what does this all mean for you, the listener? If you are an employee who has signed an arbitration agreement, and statistically you probably have, this case serves as undeniable proof that those corporate contracts are not invincible shields.
They can absolutely be broken.
Your ability to access the public court system, to have your grievances heard by a jury of your peers, might depend entirely on the specific tactical mix of claims you and your lawyer can legitimately bring forward. But this ruling also leaves us with a fascinating, high-stakes strategic dynamic moving forward for corporate America.
It undeniably scrambles the calculus for both sides in employment litigation. The tactical chessboard has been flipped over.
I want to leave you with a provocative thought to ponder, something that builds on everything we've discussed today about the realities of corporate defense. If one single plausibly pleaded sexual harassment claim possesses the radioactive power to void an entire arbitration agreement for a massive multi-claim lawsuit, how will employers react?
That's the multi-million-dollar question.
Will major corporations eventually decide that the risk is too high and simply stop using broad arbitration agreements altogether, deeming them not worth the paper they are printed on?
Or will they go the other route?
Right. Or, conversely, will we see companies start aggressively offering massive, immediate, and highly lucrative confidential settlements for harassment?
Yeah.
Claims the absolute second they are reported to HR.
To nip it in the bud.
Will they pay a premium to quickly extinguish the harassment claim, specifically to keep the rest of an employee's lucrative grievances safely trapped in private arbitration? The EFAA fundamentally changed the rules of engagement, but the strategic high-stakes game of employment law is just beginning.
The ripple effects of this textual interpretation will be fiercely debated in corporate boardrooms and plaintiff law firms for years to come.
Thank you for joining us as we explored this pivotal case. We hope you feel a little more informed and a lot more prepared for whatever the modern workplace throws your way.
If you like the Employee Survival Guide, I'd really encourage you to leave a review. We try really hard to produce information to you that's informative, that's timely, that you can actually use and solve problems on your own and at your employment. So if you'd like to leave a review anywhere you listen to our podcast, please do so. And leave 5 stars, because anything less than 5 is really not as good, right? I'll keep it up. I'll keep the standards up. I'll keep the information flowing at you. If you'd like to send me an email and ask me a question, I'll actually review it and post it on there. You can send it to mcarey@capclaw.com. That's capclaw.com.